On the point of intellectual property, it's really important to understand sort of what your pick a right strategy that makes sense for your market. We're sort of straddling two different markets, right? So on one side, you have the general Web 2.0 software industry, which doesn't really, it's all about traction. It's not so much about, hey, you have patents that actually make your company better. On the other side, if you look at sort of healthcare, biotech is all about IP. And you know, companies are built and sold for the IP and not necessarily because they have traction.
In life sciences, especially when you are looking at a novel therapeutic, a novel pathway, a companion diagnostic right from the get-go, addressing real high unmet medical needs in the cancer field, your IP has to be watertight.
We thought about IP, and it came up, and we thought hard about it early on and decided very purposely to ignore it. There's definitely IP in what we've built. There's no question that we've built some interesting things there. There's also no question that if there's no business case behind this, then there's no value to the IP. And it would only slow us down to file and only cost us precious capital early on to file it.
I feel like patents definitely are necessary in order to get any financing, for sure. You have to have protectable patents.
We are well aware that large companies, when they do partnerships or patented licensings with small companies, will be spooked or will walk away if there has not been a freedom to operate analysis done in that area. So believe it or not, over the past 18 months, we have reviewed 1,600 patents in our part-time with the two founding scientist professors, myself and our patent agent, and we made sure that in certain areas we had freedom to operate.
You have to be very, very disciplined about what can I file now, what can't I file now, maybe capital is the reason. Maybe I cannot talk about that right now. I put it into my black book, date it, and I wait till I raise capital and take it down to a good IP firm.
So the second phase of our intellectual property development was to hire the best attorneys that we could find in Silicon Valley with a lot of experience in life sciences. So we've racked up hundreds and hundreds of thousands of dollars in legal fees and haven't paid anything yet until we really are further down the road. So they've taken a risk on us, and that's sort of the magic of Silicon Valley. Big attorneys will take risks on small companies because they expect at some point to get a payout, and it's worth the risk, and it's exciting.
We approach IP along two fronts. The first front is filing early and often. So I believe heavily in the provisional filing process. We file regular provisionals with the U.S. Patent Office. Second, we pursue the PCT route. So we do not go to national filings after provisionals. We file then a subsequent PCT application, which buys us a placeholder in myriad geographies and will allow us then to select the geographies that are important down the road. The big benefit there is it offsets costs.
Where we really look at everything as layers of an onion and thinking about everything from composition of matter to the target to methods of use, but really trying to create something that is intricate enough and complementary enough that it's not any one single piece of this that is the protection, but how all those pieces come together.
So IP is one of the most difficult, challenging, frustrating things I have to deal with. It's such a complicated process. Not just the filing of patents and so on and so forth, but really understanding the ecosystem of that particular patent and the number of other patents that are out there, and the fact that patents are by no means clear, ever. I can't think of a single patent that we have that people haven't said, oh yeah, but they could get around that in this way, and that we haven't said the same about their patents.